Hi, my name is Charles Wells. I'm making this video for Katie Pasitny and her mom Karen, who are having the problem out at the Universal Ostrich Farm. Um, I'd like to pass along some information that I've garnered over the years, and I think it might be useful to you in your current predicament. Now, let's start off by saying that I'm not a lawyer and I can't give you legal advice, and this should not be construed as legal advice. What I'd like to talk to you about are what I consider to be lawful actions that you can take to remove CFIA from your property for good. It's a bold claim to make, and it needs to be backed up with some significant evidence. And that's what I'd like to do here in this video. So what this would ultimately culminate in is a notice of trespass to CFIA to leave your premises. And you would provide this notice of trespass to the RCMP with the supporting evidence. The RCMP have an obligation to investigate new evidence that's placed before them. Right now, the CFIA is acting on what they consider to be their right based upon the information that's contained within the Animal Health Act. The RCMP are there to maintain the right. That's one of their roles and responsibilities as part of the Crown, the executive branch. They execute the law. So from their perspective, the RCMP's perspective, and the perspective of CFIA, they have a legal right to be on your property. And until they have information that would change that perception, they will maintain that right. You just don't have the information to give them, and that's what I'm here to do today. So, where to begin? I'm the creator of something called The Remedy. I've probably mentioned this a few times on your Facebook page, talked about, learn the remedy, learn the remedy. I spoke to your mom about this a little bit the night before you guys flew off to Ottawa to have your case heard at the appellate level. I didn't get a chance to talk to you, but your mom asked me to get back in touch with her, and I've tried to reach out with some emails, but I haven't heard back. So I'm making this video so that it hopefully will help you understand what it is that I'm talking about. Now, there's a difference between legal and lawful. Right now, CFIA has what I consider to be the legal right to be on your property. The lawful authority doesn't exist, though. They might believe that it does, but it doesn't. There's a difference between legal and lawful, and most of us get caught up in this world of only thinking about things that are legal or illegal. And nothing wrong with that, per se. It's just that lawful is a higher standard. Legal refers to matters that pertain to acts, statutes that have been passed in a legislature. In Canada, that would be either the Parliament or the various legislatures of the provinces in terms of provincial law. Now, these statutes are presumed to be lawful, which means that they would be consistent with the provisions of the Constitution. From time to time, cases are brought to the Supreme Court, and matters are presented to the court regarding the consistency of parts or sections or subsections or clauses or subclauses within these acts and their consistency with the Constitution. And that's likely what your lawyer is doing right now. And there's nothing wrong with that. Your lawyer is sure is doing great work. This is not to disparage your lawyer in any way. However, they are doing those challenges based on the Charter of Rights and Freedoms. Again, nothing wrong with that. But the problem is that it subjects you to the Section 1 of the Charter. And just, in case you're not familiar with that, give me a second here and I will pull that up. Okay. Rights and freedoms in Canada. Section 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So when you're going down the charter path, this can typically be used against people to negate their rights. So the court, in their wisdom, will come up with reasons as to why they believe that your rights should be limited in a specific instance. And again, there's nothing wrong with this. This is a legitimate thing for the Supreme Court to do. But when you use the charter, you have to understand that you're subjecting yourself to that section. So any justice will tell you that there can be more than one reasonable answer to a question. And if they do actually hear your case and there's a decision, there will be reasons either for or against your appeal to the court. The majority will either rule for you or the majority will rule against you. And conversely, the minority will either rule for you or the minority will rule against you. And there's a lot to be learned from reading the reasons on both sides, because the men and women that sit on the Supreme Court are incredibly intelligent people who have very honorable people who have a lot of experience and a lot of knowledge of the law. And I truly believe that they do make the right decision in the vast majority of cases. Whether I agree with them or not is another story, but I have faith that they're doing the right thing, and I look to their decisions to try and learn so that I can better understand why they're making their decisions, because it usually falls on something that I don't know that they do, and I can learn from reading those decisions. Now, with that being said, there are other parts to the Constitution. You are not limited to using the Charter of Rights and Freedoms. I want to draw your attention to a part of the Constitution. Okay, this is Part 7 from the 1982 amendments. Very important part. Part 7 General reads as follows. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Now, there's a bit to unpack there. It's not particularly complicated. It's my understanding that the Constitution of Canada is actually written in grade 9 English. It has to be, because this law pertains to a vast majority of people, almost all Canadians. No, it does apply to all Canadians, but it's written in a manner that the vast majority can understand. So if you're younger than grade 9, you might have difficulty with this. But if you have a grade 9 education, you should be able to understand these words. So the Constitution is the supreme law of Canada. Okay, that means it's, number one law. There is nothing above the Constitution. Everything flows from the Constitution. Doesn't matter about the Canada Health or the Animal Health Safety Act. It is below the Constitution. Then it goes on to say any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. So what your lawyer is doing is taking either a part or a section, a subsection, clause, subclause from within the Act and going to the court and making arguments as to whether those provisions are consistent with the various rights that he might bring up in your defense. And again, absolutely nothing wrong with that. Absolutely honorable thing to do. But the Constitution doesn't say that you're limited to using the Charter. The vast majority, if not all of the cases, though, go down what I call the Charter path. The lawyers will always take you down the Charter path. Follow the Charter path. And that makes you subject to Section 1, which can work in your favor or it can go against you. So the last part where it says, to the extent of the inconsistency of no force or effect, is referring to what your lawyer is doing. So if your lawyer is successful in what he's pleading to the Supreme Court, then what can happen is those parts, sections, subsections, clauses, or subclauses would be repealed by the court. They'd be struck by the court. They would no longer be part of the law, part of the Animal Health Act, but they don't throw out the whole act. They just throw out the parts that they deem to be inconsistent. And that's what to the extent of the inconsistency means. Just the part that you're talking about. So what I want to do is talk to you about something that's far more powerful than that. What I want to talk to you about is the enacting clause from the Animal Health Act. Okay, now, just give me a second here. I'm going to go to the Animal Health Act. You'll find this right in the beginning, at the very start of the Animal Health Act. SC, Statutes of Canada, 1990, Bill C-21. C-21 is referred to. Assented to on the June 19th of 1990. Assented is what has to happen for a law to be enforced. It doesn't actually enact law, but assent comes first. Assent means that the Crown is willing to enforce this law. That's what they're assenting to. Assent is a noun. You cannot assent a law into force, because enacting is an action. Again, this is grade 9 English. Enact, act, it's right in the word. It's an action. It's a verb. Assent is a noun. It's describing a person, a place, or a thing. What they're describing is their consent to enforce the law, because that's the Crown's responsibility under the Constitution. They are the executive branch. They have executive power of and over Canada, and that's clearly stated in Part 3 of the Constitution. I won't go into that right now, but if you'd like, take a look, read Part 3 of the Constitution, and you will learn that the Crown, the King, in this case, formerly the Queen, have the power to enforce the law. And if you pay attention, the police officers that are at your property are part of the executive branch. They're part of the Crown. They are there to assist in investigations, arrest offenders, and to maintain the right. And they're doing their job. What the Crown can't do is enact federal or provincial law. That's forbidden. We'll get into that in a second. But first, I want to draw your attention to the very first words. So this has a preamble that basically lays out the intent of the act. An act respecting disease and toxic substances that may affect animals or that may be transmitted by animals to persons, and respecting the protection of animals. Okay? Lofty goals. Great. Don't have a problem with that. We all should support that. My issue is with the next part. What it says next is very important, so pay close attention. It says, Her Majesty, referring to Queen Elizabeth, because this was passed in 1990. Her Majesty, by and with the advice and consent of the Senate and the House of Commons of Canada, comma, enacts as follows, colon. This is a complete sentence. It's contained, has 3 phrases. The first one, Her Majesty, is where the subject of the sentence is. Again, this is all grade 9 English. Her Majesty, the subject of the sentence. Then we have the last clause, which is the predicate. This has the verb in the sentence. Enacts as follows. Her Majesty enacts as follows. In the middle, we have another clause which doesn't have the subject and doesn't have a verb, but it does provide some nuance and some context into what is happening. That clause says, by and with the advice and consent of the Senate and the House of Commons of Canada. So there's no verbs in there. Those are all nouns and conjunctions. It states that Parliament just gave their advice and consent and said, yeah, you do it. We're not willing to do it. You do it. This is a problem. This is a major problem. This is the source of our enslavement initially, essentially. This has broad applications beyond what's happening to you, but let's stick to your case right now. Okay, why does this matter? All right, again, I'm going to go back to the Constitution. So as you can see, all of this stuff is not my conjecture. There's not some kind of free man on the land argument. Don't let anyone tell you that this is a free man on the land argument or sovereign citizen, anything like that. This has nothing to do with people who go down that road. Okay? This is the remedy. This is my work. I call it the remedy. As far as I can see, it's an original treatise, thesis, if you will, on our situation in Canada today. So what I'm going to do is I'm going to go to part 6 of the original Constitution, the old part, which has been around for 158 years. So this has been there since day one. Part 6, distribution of legislative powers. This again is very important. This lays out the limitations of the jurisdiction of the federal government and the limitations of the jurisdiction of the provincial government. Later on, I might get into what's known as the residual theory of POG. You've probably never heard of this. This is an embarrassing piece of Canadian jurisprudence that has existed for just over 100 years. It's never been challenged, and I'm embarrassed that no lawyer has ever challenged this because it is so blatantly false that it beggars belief that no one has ever done it. But as far as I know, I'm the first. But we'll get to that later on because it's sort of a subsection to what's going on here. So this is the section, part 6, that not only lays out the limitations of the powers for the federal government and the provincial governments, it also grants what I'm going to consider a limited power to the executive branch to make law. Because there are classes of subjects assigned in the Constitution to the Parliament and the provinces, but there may be others that are outside of that are outside of their jurisdiction. And from time to time, those matters might have relevance to the nation as a whole, so somebody has to have the authority to make laws regarding those matters. And that falls on the Crown. And this preamble to Section 91, preamble meaning coming before, is, in my opinion, one of the greatest pieces of literary work ever. The Canadian Constitution is a marvel. It should be the envy of the world. If you really study it and look at it, it's an amazing document. It's full of so much information and empowers us a great deal, but you really need to read it. So we'll start with, it's about 111 words long, if I'm not mistaken. I've read it many times. And it says, it shall be lawful for the Queen, comma, by and with the advice and consent of the Senate and the House of Commons, comma, to make laws for the peace, order, and good government of Canada in relation to all matters not coming within the classes of subjects by this act assigned exclusively to the legislatures of the provinces. Now that's the first half, okay? The second half says, and for greater certainty, but not so as to restrict the generality of the foregoing terms of this section, it is hereby declared that, notwithstanding anything in this act, in brackets, the exclusive legislative authority of Parliament of Canada extends to all matters coming within the classes of subjects here, next, hereinafter, enumerated, that is to say, comma, then it goes on to list the parts, the sections of, no, pardon me, the classes of subjects in section 91 that the federal government has jurisdiction over. Now there's a lot in that preamble, but what I'm saying is that this is granting the Queen, because at the time this was written, you have to understand this was written for Queen Victoria. So technically this should have been amended many times because we've had, what has been, 5 kings. We're on our 5th king since the end of Queen Victoria's reign, but it's never been amended. But I'm sure that the court looks at this as being a technical matter, and they would insert the word king now, currently, where it says queen in the document, to understand that this power would be either the queen or the king, as the case may be from time to time. Now, if I'm wrong on that, the Supreme Court is more than welcome to, enlighten me. But that's my interpretation, that this would apply to both the queen or the king, as the case may be from time to time. So the first part is easier to see because it clearly says that the queen can't make provincial law. When it says, in relation to all matters not coming within the classes of subjects by this act assigned exclusively to the legislatures of the provinces. So those of you who are listening who have problems with provincial law, pay attention. This applies to provincial law as well. We're dealing with federal law at the moment. So this is the beauty of how this is written. It's written by people that are just so, the command of the English language is just so far beyond mine. It's just amazing to read and appreciate. But what they do in the second half is say essentially the same thing, but they say it in a different way. What they do in the second half is that they say that the classes of subjects that are assigned to the Parliament are exclusively the Parliament's. So that means that the Queen cannot enact law that is under the jurisdiction of Parliament. So to give you an example of how this would apply to the Queen or the King, in 1982 there was a constitutional amendment. It wasn't the government that amended the Constitution. The government can't amend the Constitution. The government can ask to have the Constitution amended, and that's what they did. They asked to have it amended. If you recall, the crown is at the top. The crown creates the Constitution. So the Constitution is the creature of the crown. The creature is never greater than the creator. Okay, now the Constitution creates the 2 orders of government, federal and provincial, Parliament and the legislatures. There's only 2 orders of government. So if you're in a municipality, pay close attention, because you guys aren't a lawful order of government. Never have been, but that's the sidebar. Anywho, this means that because the government is the creature of the Constitution, the government can never amend the Constitution. The government has to ask the Crown to amend the Constitution. And that's what happened in 1982. The Queen came over here. The Queen enacted the amendments to the Constitution because that's her role in accordance with what it says in the preamble of Section 91. The Queen does have power to make law, and so does the King. People have this false belief that the Crown is some archaic remnant of a bygone era. I mean, just look at all your money. Whose face is on the money? Whose face is in every courtroom? The highest picture in the room is the Queen. And any RCMP office, you see pictures of the Queen. Government offices, pictures of the Queen. King now, currently. Queen, King. They have executive power of and over Canada. That's stated in Part 3. They have enormous power. But people have been led to believe, my opinion, by media, that they're just there to, pomp and circumstances, and they don't really have any power. But rest assured they do. And they exercise it when necessary. And in the case of the 1982 amendments, that was necessary because the government can't amend the Constitution. So, getting back to the Health of Animals Act, when it says Her Majesty, by and with the advice and consent of the Senate and the House of Commons of Canada, enacts as follows, well, that statement would be correct if she was amending the Constitution, but she's not. This is federal law. What this should say, now this is my opinion, the Supreme Court could weigh in on this if they want and tell me that I'm wrong or it should be worded differently, that's fine with me. But my understanding would be that it would have to be written to say that make the House of Commons and the Senate, or no, the House of Commons the subject of the sentence. So it would start with the House of Commons, comma, by and with the advice and consent of the Senate and the royal assent of His Majesty, or Her Majesty, as the case may be, comma, enacts as follows. It would be the Parliament that's enacting. The Parliament would be the subject of the sentence. The predicate, enacts as follows, would apply to them. The part in the center would be the nuance, where it says that the Senate has given their advice, and that's what they do. They have debates in the Senate, and then they vote on it. If they've voted to pass it back to Parliament, then they've given their consent. Now, it's jumped through those hurdles. The Queen's reviewed it, King's reviewed it, whatever, and they're in agreement that they will enforce this law. Then they assent to it. That would happen prior to this, and that's what this act says. Before this statement of enactment is, it tells you that it was assented to on June 19th. So that happened first because it's written first. Everything's in chronological order here. Assent comes first, then the proclamation of enactment, then the enacting clause. Who's enacting it? So right now, Canadians live under the tyranny of the Crown because this is how all acts are done. Your elected officials do not enact any law. They never have. If you look at any provincial or federal statute, they are all written this way. So you can complain to your MP or whatever. Those guys, their hands and girls, their hands are clean. They're functioning, it's my opinion now, in breach of trust. What they're doing is delegating away our right to self-government over to the executive branch. So this puts the Crown in a difficult position because we, the people, aren't telling our elected representatives what we want in terms of law. We just don't. This information comes from primarily industry and corporations. And so to be honorable, the MPs, they can't enact that because it's not coming from the people. It's coming from a dead entity, corporation. So they can't. But somebody has to make rules to make this place work. It's our fault. This is on us. So don't be pointing fingers and blaming the MPs and pointing fingers and blaming the Crown. This is all on us. We have to change. Not them. They do have to change, but they won't change until we show them that we're self-actualized adults. We present as children to the Crown because we don't defend our rights. We ask for our rights back. You ask for your rights. I don't do that. I go into court and I would say that this person over here is infringing upon my right. I've never lost my right. It's part of my body, like my bones in my hand or the blood in my veins. It can never be taken away from me. It can only ever be infringed upon. That's what I do. You know, like the truckers, they went to Ottawa and they asked for their rights back. Right? I don't do that. You don't ask. You defend. That's what adults do. And that's what the Crown is waiting for us to do, to step up and defend our rights. They've been patiently waiting for 158 years. They'll wait for 158 more. They don't care. They're waiting for us to show that we understand that we have allowed ourselves to be fooled this whole time. Queen Victoria set Canada up to be a democracy. It's what it's set up to be. But you don't live in a democracy because your elected officials delegate away your right to self-government, which, in my opinion, could be construed as breach of trust. But we're putting them in a bad position because we don't actually tell them to make law. So that's, in a nutshell, the reasoning behind why the Animal Health Act is now of no force or effect in its entirety. So what your lawyer's doing is he's arguing about something that's within the act. And maybe he'll be successful, but maybe he won't. If he's successful, they toss that part. What I'm saying goes to the enacting clause. When you can show to the RCMP that the enacting clause is of no force or effect because it's inconsistent with the provisions of the Constitution, specifically the preamble of Section 91 of Part 6, therefore in accordance with Section 51 of Part 7 General, it is rendered to be of no force or effect in its entirety. Everything that is said after that blows up. It's gone. Doesn't matter what it says after that. I don't care what the act says. Talks about different sections. We have the right to be on your property. We have the right to do this. We have the right to do that. You know, anyone who contravenes section blah, blah, blah is, guilty of an offense, whatever. I don't care what it says because it's of no force or effect. This is very powerful stuff. So pay attention. If the Supreme Court refuses to hear your case, and they might do that, and that would be legitimate in their eyes because what I've told you today is not before the court. The court can't act on this until it's presented to the court. Okay? It's never been presented in any of the other cases, so I've been holding back on this for quite a while because I wanted this process to kind of go through so you'd understand better maybe now what's happening. So you lost all of your appeals because the information before the court essentially comes from the Health of Animals Act. So that's what the court has to interpret. Okay, so what I'm giving you is the keys to the kingdom. This gets rid of the Animal Health Act in its entirety. There's nothing for the court to consider anymore. And this is now becomes the grounds for your notice of trespass. When you negate the Animal Health Act, they no longer have a right to be on your property. Have a nice day. Pack your and go. Hasta la vista, baby. And the RCMP are there, and they're there to maintain the right. Now, you've exerted a right that supersedes theirs, because their right, remember, they have a legal right, because it's based on the statute passed in Parliament. Your right is up here, the Constitution. What's down here is inconsistent with what's up here. So this goes away. It's very powerful stuff. If you'd like to contact me, learn more details, we can chat. But for now, I'm going to leave it here, and hopefully this will be enough to either pique your interest or, like most people, to just disregard it, which is fine by me. I'm not here to force this on anybody. I'm just passing on information. Everything that I've presented to you today comes from A, the Constitution, and B, the Animal Health Act. So it's not a conspiracy theory. It's just simply the truth. And the truth will set you free.